Right now, the Supreme Court is debating the most significant case in America's history for the last 40 years. This case has the potential to give Republicans anywhere from 19 to 27 seats in the House, practically sealing up Republican control of the House for the years to come. It also abolishes an amendment to the Voting Rights Act that establishes disparate impact. This might not sound interesting. As a matter of fact, it probably sounds boring, but this is the idea that generates an enormous portion of the legal backing for far-left legislation. Abolishing disparate impact would absolutely devastate the Democrat legal foundations of their policies. As an added bonus to all of this, nullifying and rendering useless any attempts that Gavin Newsom makes in California to redistrict with Proposition 52. It also has implications for other areas of government, including DEI and affirmative action. The left is panicking over this case, so I can literally look through this camera and see you jumping out of your seat. So you're asking, what is this case? Well, I'm going to tell you. It's Louisiana versus Callais, and it's the Democrats' worst nightmare, because it's very likely that the Supreme Court is going to reverse the core decision of that case. Now, if this doesn't sound big yet, let's get into some details. Louisiana versus Callais centers around Section 2 of the Voting Rights Act, in particular, one extremely important amendment to the way it was written. It's this amendment that has been the source of Democrat power and the irrational logic that has fueled it for the last 40 or so years. Section 2 of the Voting Rights Act makes it clear that state and local governments cannot have election systems or practices that discriminate against voters of color. Seems like there should be no problems with all of this, right? Well, you know what? There actually was. The problem was found in the amendment to the Voting Rights Act in 1982. It changed everything. The core premise of the Voting Rights Act went from noble to destructive with just one stroke of the pen. In 1982, Congress amended Section 2. They changed it so that any proof of racially discriminatory impact, key word there being impact, is sufficient for a violation of Section 2. There no longer needs to be discriminatory intent or anything else to prove discrimination, only impact. So what does this mean in practice? Well, in the real world, this means that the reasons and the reality generating the statistics that drive the changes in politics simply no longer matter. Literally, the only thing that matters is the impact or the results of whatever legislation was passed. Let's do a non-political hypothetical to visualize all of this. Imagine a group of people who eat apple pie all the time, so much so they drain the city's supply of apples. Apple farmers simply can't keep up. They farm all day, but the shelves are short. Apple pie is running out, and the people who eat it are furious. They claim discrimination. Why? Because there is no apple pie, and this is all they eat. They have been impacted by the absence of apple pie. Does it matter that the farmers are working hard and trying to produce apples for them? Nope. Intentions are no longer the consideration. Does it matter that the people eating apple pie probably should switch off to maybe something else in their diet? Nope. That doesn't matter either. The realities of those people and the self-responsibility of their own behavior no longer matter as well. The only thing that matters is these people have been impacted by a shortage of apple pie. So now the Supreme Court has no choice. They must rule that farmers are discriminating and the people hogging up apple pie have been victimized. Does this all sound ridiculous to you? It probably does, and it should. Now, this, of course, is a hypothetical that I just made up, and I exaggerated it to prove a point. The real world is different. So let's look at a real world example of the problem of what judges know as disparate impact. Take universities, for example. Universities have to let in a number of people based on race, because if they don't, the impact on race they don't let in will be considered discriminatory. It doesn't matter whether or not the races of the people they live in have genuinely earned their way or not. The self-responsibility and other factors that contribute to whether or not people of any race qualify for admission simply no longer matter. The threat of disparate impact is the beating heart of what legally drives affirmative action. They're getting in, and what they've done in the past doesn't matter. It's all because of their race. And this is just one example. It also drives legislation around other federal laws like those dealing with housing and employment discrimination. The bottom line is this: if the federal government is prohibited from discriminating on the basis of race, then surely it is also prohibited from enacting laws mandating that third parties discriminate on the basis of race themselves. So how does all of this translate to Republicans taking 19 to 27 seats in the House? That doesn't seem to make sense, does it? Well, it does. If the Supreme Court does invalidate Section 2, then all of the Democrat maps that were redistricted in order to account for disparate impact over the years, they will have to be reverted back to the way they were before the manipulation. This means not everything, but pretty much everything goes back to Republicans. So let's break it down and explain it even further. This is where Louisiana comes in. After the 2020 census, Louisiana, like almost every other state, redrew its congressional districts to account for disparate impact. They claim that black people did not have districts of their own, so the impact was discrimination. Then they drew a district that was composed of almost all black people. This was initially a legal success for them. Then they drew another district for black people in 2024. Well, people were upset and challenges arose, one in particular from Philip Callais. And this is where we know the case now as Louisiana versus Callais. And much like Justice Scalia talked about, the challengers actually won this time. Well, kind of. Philip was arguing from a constitutional viewpoint, not necessarily a statutory viewpoint. They claimed that our Constitution guarantees equal protections for all, and drawing up districts for black people only is racial discrimination. So, here's where it gets tricky. The state court denied the second district. Philip initially won. Small victory. But then the Supreme Court stepped in, and they said to allow the second district. However, put the brakes on. We're going to reschedule a discussion about all of this in 2025. Why? Well, because, like Scalia said, there has to be a discussion of whether the legality of disparate impact and our constitutional right to equal protection actually can coexist and make any sense whatsoever. It was the Supreme Court justices who were the ones who brought this subject to the table for discussion. This was not the Trump administration. You know, people on the left are going to try to blame him or point fingers at him, but the truth is, this has been scheduled for quite some time. And this pretty much sums up where we are. So, here's some personal points on the matter. If you made it this far, I appreciate it. This is just my personal take. This is a seemingly touchy situation to some people, but I really don't think we need to be concerned. The days of being touchy about racial matters are over. The year is 2025. We are 7 to 8 generations removed from the days of the Civil War. Somewhere around 650,000 white people died in the Civil War. That people is reparations. We have black people in Congress, millionaires, professional athletes, musicians, movie stars, and we have also had a black president for 2 terms. We also live in a country where people of color from all over the world desire to come here. America is the country that statistically most people aspire to live in. And if we look at income levels of different races all throughout America, we find it is a good mix of everyone all over the place. There is no longer reason to bend over backwards and destroy logic in order to twist laws into something as irrational as disparate impact. Those days are over. Last point, the Democrats of the early 20th to mid 20th century were pro-civil rights and pro-America. This is no longer the case, and I can't stress this enough. The Democrats of today are anti-civil rights and anti-America. They are fueled by power grabbing. They use violence as a means, along with poorly written, cynical university theories that are destructive to manipulate people. I hope the Supreme Court does the right thing and upholds the constitutionality of equal protections as the ultimate law of the land. Disparate impact is completely irrational. And that's it for this video, everybody. Thanks for watching. I appreciate it once again. See you in my next one.